Welcome to 3906 Chambers webinar on the latest developments in local government law. I'm Fenella Morris QC and I've got with me Sian Davies, who is going to speak to you about ordinary residence disputes and disputes between local government and the NHS, which continue to rumble on. Then we're going to hear from Jack Anderson, who's going to talk more about the host of social services issues that we have to grapple with at the moment. And then last of all, Tom Amraoui is going to speak to you about education law. But I'm going to start first of all, and I am going to talk to you about decision making. Now, the key thing to bear in mind is that in terms of decision making, all the usual rules apply. And it's important to keep a hold of those fundamental rules when you're trying to get to grips with the new world. And it seems to me that some of the key ones are these, that when you're going to make a decision, you need all the relevant information. One of the ways of securing that is by communicating with the public, by making sure that they can have access to the material that you're relying on in order to make a decision, and allowing them to contribute. The other key principles to keep in mind are access and also transparency. And I think that those are the ones about which people perhaps have most anxiety in this new world. And the last one really is the value of public involvement. And if you think back perhaps to the decision of the Supreme Court in the Mosley case, all the things that local government get from making sure that their local community is properly involved in decision making. They get information which allows them to make better decisions. They're able to take communities with them, and they're able to make sure that the democratic principles are observed. Now, the first thing really to hit local authorities in terms of process when the crisis started were these extraordinarily named regulations, and I'm not even going to try and read them out. And perhaps the key things that those regulations provided for was virtual meetings, as well as all kinds of means of communicating digitally. Now, if you look at what commentators have said about these regulations, it seems that people think that perhaps in lots of ways they could have been a good thing because they gave people more access, people who perhaps ordinarily couldn't get to a meeting. But on the other hand, there were worries that there was going to be too much access, and people were going to see things and then perhaps complain about misconduct. Equally, there were worries about confidentiality. Now, as far as I'm aware, there haven't been any express challenges brought relying on these regulations, but I think it's worth mentioning to you that in a planning case that one of our colleagues was involved in, Richard Harwood, the Holborn Studios case, which was handed down this morning, a decision in the planning context, although taken before all of this happened, was set aside because there hadn't been sufficient public access to documents. And also in reliance on the right of the public to be able to communicate with their elected representatives. And the worry in that case was that those who were making the decisions hadn't been able to see the detail of all the representations that were made by members of the public. So there's clearly risks lurking out there for the unwary. The other thing I want to mention under this heading was the fact that the Secretary of State has issued guidance encouraging councils that do have them to use their urgency powers to delegate some decision to officers. But it seems to me that for the reasons that I've just mentioned, that's fraught with a risk. Now, the other area which has caused lots of difficulty is consultation. And perhaps that's always something that's difficult. But it seems to me that it's a critical issue for people at the moment because there are lots of decisions that still need to be made or that are coming up. Now, what does seem to have happened is that lots of consultations have carried on, but they've gone online or digital and they've extended time. And so I would tend to suggest to people that if you've still got one going on, it could be in lots of ways desirable just to keep going and modify it and make it take longer. On the other hand, there are those who say, well, if you don't actually have to make a decision now, and you could quite safely and sensibly make it in a year's time, it might be a good time to give up particularly if there are, as there are for many local authorities, a lot of pressures on your resources. The other factor that I think you ought to take into account if you're considering whether or not to carry on with your consultation is whether the landscape around the decision has changed so much. Obviously, there's been huge change in health, social services, education, planning, all kinds of areas. And it may be that so much change has happened that the kind of options that we're consulting on are not really what everybody is thinking about now. The other thing to bear in mind are the characteristics of your consultees. Now, anybody who's been involved in consultation will know that there's been a huge amount of work done in the last couple of years about consulting with people who are hard to reach, people who have communication limitations, who are itinerant, but who are vital to making decisions. And so one of the key things to think about is who really is your constituency for this consultation, and are you going to be able to communicate with them adequately with these alternative methods? If you're thinking about new consultations, one of the things that I would ask local authorities to keep in mind is that they've probably made quite a few crisis arrangements, and careful thought needs to be made about whether you can lawfully leave that in place without consulting on it. And I think that's a real risk, that we'll have put things in place because they needed to be put in place, but you can't just let that necessarily become the new normal if it's the kind of thing you really ought to have consulted about. The other value of a new consultation seems to me that it perhaps creates more opportunities for creative solutions. We know that society has new problems, that we've also tried lots of new ways of doing things. Another value, it seems to me, of starting a new consultation is this maintenance of transparency and building trust with communities. We know that lots of people are very fearful. We know that there's been a real outpouring of alienation in relation to issues around race. We know that there are lots of complex social issues that local authorities are going to need to grapple with as we come out of lockdown, and that having a good quality consultation might be a way of building that. The other thing to bear in mind is the sophistication of the digital solutions that are available. And I went and had a look on the Consultation Institute website, and they've got a huge array of providers who do all kinds of really attractive digital options. And they also suggest you go back to some of your tried and tested and see if there are features you haven't used. The other thing that the Institute recommends is doing more active listening by social media, kind of tuning in to what's going on local social media to see what the hot issues are before perhaps you get as far as engagement or consultation. And it seemed to me that that was a really interesting way of responding and building in at an early stage local change to your plans. Now, the other part of this talk that I wanted to put out there was something on the more sort of optimistic end of the spectrum, and think about what opportunities are there for local authorities as we start to come out of the crisis, and as we think about how we can rebuild communities, how we can rebuild local authority coffers, and how we can develop and learn from what's happened. There will have been lots of changes in services in lots of areas. And it seems to me that's a chance to say, well, look, are there things that we've been doing that work really well? It seems to me that's the other side of the coin to the, well, don't just leave things in place. But if you've done something and it's worked well, it may be that you shouldn't just leave it in place, but you should consult on leaving it that way, because it also may have given people the opportunity to experience change and feel good about it. Because I think we know that one of the big obstacles to change often for local authorities is communities not wanting change, but perhaps they've had some change thrust upon them. You think it's working well. Maybe that's the way to take things forward for the future. There also might have been changes in community. Perhaps people have started to work together in a new way. Or perhaps because of all the digital change, you can see that there are new ways of involving people. There have been some recent changes in legal frameworks, which it seems to me are worth mentioning, which give real opportunities for local authorities. The first of those is some guidance from the Secretary of State about the requirements for having a referendum in relation to the local plan. You may well be aware that regulations have provided there shouldn't be any referenda until next May, but of course that makes life tough for local authorities if they've got things in the pipeline, like a plan, that ordinarily ought to be subject to that. Now, what the guidance is saying is you can give very great weight to that plan as you seek to make plans and make decisions and go forwards, even if you haven't been able to have a referendum about it. The other really exciting opportunity for local authorities that I've seen is the enormous relaxation of state aid rules. And it seems to me that that is perhaps where most creativity can come to the fore, and gives local authorities real opportunities as well for perhaps starting to solve some of their financial problems, and also dealing with some of their concerns that they may have about public health. Because of the relaxation of the state aid rules, that gives currently local authorities the opportunities to go into a lot more partnership arrangements where they take a financial interest in something, which may, seems to me, generate revenue for the future. In that context, I wonder whether more thought ought to be given to partnership with sporting organisations, for example, who themselves may be having difficulties, but may perhaps form the core of a new programme which is focused on exercise for public health, and also focuses on revenue generation or forms the centre point of some other regeneration project. And it seemed to me, therefore, that local authorities should be increasingly outward looking in looking for new partners in order to devise projects, perhaps also not only in relation to sport, but in rebuilding of the high street. Now, I'm hoping that Sian has been able to look at any questions that have come up. What I probably should have mentioned at the outset is we're going to take a few questions at the end of each of our talks, as well as having a chunk of time at the end for questions. And the other thing is, if you suddenly wake up this afternoon and think, oh, well, I wish I'd asked about that, I should remind you that Chambers has a quarantine queries service. And that means that we're giving local authorities 30 minutes of free advice, and you just need to contact our clerks. And I know that we've had lots of really fascinating topics come up that way, and we've really enjoyed chatting to you all and answering some of your wonderful COVID quarantine queries. So I'm just going to check whether Sian has got any impossible questions to ask.
Yes, so there's an interesting question here about the impact that COVID might have on the ability of certain high risk groups. So, for example, those who are BAME, who are shielding or otherwise vulnerable, to physically attend the sort of consultation workshops that have perhaps been the traditional method of local authority consultation. And then also the sort of the related point that there are going to be certain groups who don't have the sort of technological internet access that is being increasingly relied upon. And I suppose the question really is how do you strike the balance between using those traditional face-to-face methods and the kind of the new digital consultation methods?
Well, I think that's the real, sharp end of it all. I think, first of all, people who are shielding, but, are good with the internet in one sense are in potentially a good position. I think, however, the real loss is that, public meetings, focus groups, all of those are going to be more difficult to arrange and organise. And, as we all know, these new media are good up to a point, but we're all missing something from face-to-face communication. But I think potentially what's said is that people who are shielding or otherwise can't attend meetings are in a good place. I think it's the hard to reach where, there's been so much creative work done over the last few years in improving access, particularly, in areas of special educational needs or social services where you need to communicate with vulnerable people and their families. I think that's much, much tougher. I would say keep an eye on the Consultation Institute website, because they do have a lot of creative solutions, but it seemed to me it wasn't obvious. I mean, maybe it'll be, you can have, I don't know, a sort of consultation garden party, you know, and you could have 6 people, or I suppose you could have 5 attendees and someone from the local authority chatting to people. That sounds quite civilized, all right in the summer, but maybe not so good in the winter. I mean, I think it's a real tough one. I think that it'll be interesting to see that if there are challenges brought on that basis, how sympathetic the courts will be, because at the moment they've been pretty sympathetic, but equally they haven't let local authorities get away with absolutely everything. And so I think it's a bit of watch this space. Okay, well, I'm going to hand over to you now, Sian.
Okay, thank you. So I am going to talk about the thorny question, the perennially thorny question of who pays, and in particular the sort of the division between local authority and social services. And I'm going to just make sure that I'm keeping to time, because obviously you want to hear from everyone else as well. So starting with what I'm going to talk about, the sort of the normal situation, health or social care, the current situation, health or social care, whether that applies to Section 117 Mental Health Act, Aftercare, and then ordinary residents. I suspect that there are more slides than I am going to have time to cover, but you will get copies of the slides afterwards, so my apologies for that. There is a resources page in the slides. I've just put links into the documents that I'm going to refer to. So normal times, the divide between health and social care is based on whether the person needing to be looked after has a primary health need. If it is a primary health need, it falls to be met under the National Health Service Act. The mechanism for doing that is continuing health care. This is arranged and funded solely by the NHS, and can be for individuals not in hospitals but whose needs meet those primary health need criteria, and that's been the position ever since the Cochran case, which is well known. CHC eligibility is determined by reference to the framework guidance and the 2012 standing rules, and there are links to both of those in the resources page. And the duty to assess for CHC eligibility, and again, just to emphasise, I'm dealing with normal times here, comes from Rule 21 of those standing rules. So the relevant body must take reasonable steps to ensure that an assessment of CHC eligibility is carried out. The decision-making structure is the checklist, the MDT, the decision support tool, and then the CHC panel decision. And there is emphasis in both standing rules and the framework guidance on the collaborative nature of the decision. So the local authority has to be consulted, and the local authority is usually a participant in the MDT stage of the process. So the eligible patient who meets the CHC criteria has his health and social care needs funded by the NHS, including accommodation, if that's an assessed need. And the key difference for the patient is that if his needs, potentially including accommodation, are met by CHC, then he's not going to be charged. If he is not CHC eligible and the care and support is provided under the Care Act, then under Section 14 of the Care Act, and of course subject to the application of the Care Act easements that Jack is going to talk about in a bit more detail, then the local authority has a power to conduct a financial assessment, and where the financial criteria are met, to charge. So the Care Act 2014 has within it a sort of a mirror image provision. So whereas the NHS is obliged to assess for CHC, the local authority is expressly not able to provide for needs which are required to be provided under the National Health Service Act. And that comes from Section 22 of the Care Act. And that's quite important because that's a vires provision, making it unlawful for a local authority to provide services under the Care Act, which are required to be provided under the National Health Service Act, with certain exceptions. So that's the normal position. The current position is rather different, and to an extent, the normal rules have been suspended. So Section 14 of the 2020 Coronavirus Act reduces the duty to conduct CHC assessments under the standing rules to a power. So in other words, there is no longer an obligation to comply with the duties imposed by Regulation 21 of the 2012 regulations, or to comply with the provisions of the national framework insofar as they relate to the duty to conduct a CHC assessment. So instead of CHC assessments, where those are not being conducted, we have the hospital discharge service requirements. And what these say is essentially that the NHS is to fund the cost of new or extended out-of-hospital health and social care support packages for people being discharged from hospital or who would otherwise be admitted into hospital for a limited time. And the purpose of this is to enable quick and safe discharge and or to avoid admissions in order to reduce the pressure on acute NHS services. And the rationale for that is that because there is no timescale for CHC assessments, that there is a need to have a swift discharge mechanism, and those discharge service requirements talk about, for example, people being discharged from hospital within an hour of a decision that they're fit for discharge, because of this suspension of the normal, if I can call it, wrangling over whether someone's needs on discharge are going to be met by adult social services or whether they're going to be met under CHC funding. So the service requirements operate this discharge to assess model with full government funding for new or extended out-of-hospital health and social care support packages. The service requirements advise that Section 75 agreements can be used or varied for this purpose. So Section 75 agreements obviously set out arrangements as between local authorities and their partner CCGs. And clearly set out that funding under the service requirements should be separately identified. And I'm going to come back to that provision 10.10 of the service requirements when I sort of make my concluding remarks. Just a quick word about aftercare under Section 117. In normal times, the purpose of this is to meet needs arising from the mental health condition to prevent relapse of somebody who's had to be detained under Section 3. The duty is imposed concurrently on local authorities and CCGs. There isn't anything in 117 itself which deals with any sort of division of responsibility, that they are both bodies are responsible for all of the aftercare, but many local authorities and their partner CCGs have local agreements in relation to how they divide responsibility, whether it's done on a case-by-case basis, whether it's a sort of blanket 50-50 split, or whether they have some sort of pro rata arrangement depending on P's needs. And obviously in relation to dispute resolution, I would say that local agreements often do, and if they don't, ought to address the mechanism for dispute resolution. Aftercare can include accommodation if it's sufficiently connected to the mental health condition. In other words, if the need for accommodation relates to the mental health condition for which P was being treated. And again, crucially, as with CHC, a patient is not charged for aftercare provision. In current circumstances, actually no change. There's been no amendment to 117 duties upon local authorities or CCGs, and you can see that from the Coronavirus Act itself, which obviously doesn't make any reference to statutory amendment, and Section 3 of the Easements guidance, which again is something that Jack is going to talk about in a bit more detail in relation to care and support duties. Do the service requirements, so those requirements for prompt discharge, apply to 117 discharges? the position is that under the framework guidance, the order of consideration as between Section 117 aftercare and continuing healthcare is Section 117 first and continuing healthcare only if Section 117 isn't available. The Coronavirus Act and the service requirements only apply to continuing healthcare assessment. And so if a person is eligible for 117 aftercare, the likelihood is that one just doesn't get to a CHC assessment. And that fits with the sort of stated purpose of the service requirements, which is to free up the acute and community beds in light of the coronavirus crisis, which is unlikely to be relevant to 117 provision. Quick word on those lacking mental capacity. No change to the Mental Capacity Act. The service requirements, although the focus is very much on getting people out of hospital quickly, do make clear that where somebody doesn't have capacity to decide on their care and treatment post-discharge, a best interest decision is required in line with Section 4 of the Mental Capacity Act. And obviously, whatever the intentions of those service requirements and the additional funding, that has the potential to delay hospital discharge. Moving on to ordinary residents, again in normal times, relevant provisions, Section 39 of the Care Act, Chapter 19 of the statutory guidance, we have the Shah and Barnett test, which is well known, and of course no statutory definition of what ordinary residence means. The deeming provisions of Section 39 apply to effectively disapply the normal Shah and Barnett position in specified circumstances. So where a person is provided with specified accommodation, care homes, supported living, shared lives placement, where they're in Section 117 provision and where they're in NHS accommodation, the so-called deeming provisions apply. In current circumstances, ordinary residence continues to be relevant, particularly where the local authority is continuing to operate the Care Act as enacted. In other words, where the easements are not in force. Again, Jack is going to talk a bit more about the easements. Where the easements are in force, the concept of ordinary residence continues to be relevant because under the amended eased care and support duty, a local authority continues to meet a duty to those who are ordinarily resident or of no settled residence, albeit that the duty is different. It's not a duty to meet eligible care and support needs. It's a duty to meet needs in order to prevent a breach of human rights. But nonetheless, the geographical criteria is ordinary residence. And of course, Section 117 of the Mental Health Act determines the responsible local authority by reference to ordinary residents. So just a couple of concluding remarks, really. Who pays is complex in normal times. There are often disputes between public bodies, between local authorities and CCGs. Those disputes, in my experience, often require careful analysis of decisions that were made a long time ago. They involve drawing up a detailed chronology of what happened under what statutory power. Given that we have these new extraordinary circumstances and these time-limited statutory amendments, it is really important, and this is the message I would like to be taken away from this, that there is clear recording of the statutory basis upon which support is being provided, because that's going to affect future decisions as to where financial responsibility lies. And just finally, really on a related point, disputes are more difficult to resolve evidentially the more time has passed. They need to be promptly identified and notified to the other local authority or CCG so as to avoid those really difficult evidential issues where there aren't clear records and the person who created the records no longer works for the local authority or the CCG, and it's almost impossible to piece together what actually happened and under what power or duty somebody was supported. So almost on time. That concludes my presentation. Can I just ask whether there are any questions arising from that to test me?
Yeah, Sean, there are some great questions. There are quite a few, so I thought maybe we'd just do one and then leave the others to the end if we've got time.
Sure.
So the first one, I'll be interested to know whether you've got an answer to this. Someone's saying they're about to refer one of these disputes to the Secretary of State for determination. Do we know how long he's taking to reach a decision? I mean, I imagine a long time, but maybe you know a bit more about that than I do.
My experience is that in normal circumstances, they take a long time or can take a long time. And I suspect that situation has not improved and is likely to be worse in current circumstances. Sorry not to offer a more optimistic response to that question.
That's fine. I'm going to hand over to Jack now, and then we'll catch up with some more questions later.
Well, good morning, everybody, and thank you, Fenella. I'm just going to bring my slides up now and get those started. Sorry, just having some slight technical difficulties here. Hopefully that is now showing as a slideshow. I'm going to be talking this morning about social care and with a particular focus on the easements that local authorities are permitted to put into place in limited circumstances where they would otherwise struggle to meet the needs of their service users. Before considering that, I first of all just noted on the first slide a number of pieces of the relevant guidance that have been issued for local authorities in relation to dealing with the circumstances of COVID-19, including the 19th of March ethical framework, the hospital discharge requirements, which Sian has already referred to, the action plan for adult social care, and the specific guidance in relation to the provision of home care and in relation to the Mental Capacity Act and the DOLS guidance. And there are, for those who are interested, webinars in relation to the specific situations that arise in care homes and also in relation to the Mental Capacity Act and DOLS available on the Chamber's website. And our colleague Alex Ruck-Keene also has a lot of information on his personal website in relation to the Mental Capacity Act and DOLS. But I'm going to be focusing today on the easement powers. So first of all, and just by way of an overview, the easements are achieved through Section 15 and paragraph and Section 15 and Schedule 12 of the Coronavirus Act 2020, and I've set out on this slide the relevant provisions. But in a nutshell, what the easements do are first of all relieve local authorities of the obligations in relation to the assessment of need, the determination of eligibility, and the conduct of a financial assessment before providing services. And secondly, turn the duty to meet assessed needs into a power to do so, except in circumstances where it's necessary to meet those needs in order to avoid a breach of either a service user or a carer's convention rights. And that's achieved by provisions in the Coronavirus Act 2020 requiring the Care Act to be read as if it set the powers and duties out in that way, rather than by direct amendment of the Act itself. But in terms of the practicalities, the real meat in relation to the test that has to be met before putting the easements in place and the procedures that have to be followed in order to put the easements in place is set out in the statutory guidance to which local authorities are obliged to have regard. And that sets a high threshold before the easements can be put in place. The guidance provides that the easements should be exercised only where essential in order to maintain the highest possible level of service, and that local authorities should comply with the pre-amendment provisions and guidance for so long as possible and as far as possible. The guidance also reiterates those duties that remain in place for local authorities, including the duties to promote well-being and the duty to safeguard adults. And some specific guidance in relation to safeguarding is provided at Annex D of the statutory guidance on the easements. And as Sian has already mentioned, it also emphasises that the duties in the Mental Capacity Act 2005 and in relation to the doles regime remain in place, and that duties under the Equality Act 2010 remain in place. And I think that's particularly important because in any circumstances in which a local authority was considering making any systemic amendments to how it addresses care needs, the public sector equality duty under section 149 of the Equality Act 2010 will be a matter of particular importance, and it's likely to be very important for local authorities to make sure that they make express reference to the duties in that act and demonstrate how they've been fulfilled in the context of its decision making. And finally, the guidance emphasises that the ethical framework that the government has published should be applied, and that personalisation and co-production of care are as important as ever, even in circumstances where some of the formalities around the assessment process might have been relaxed. So returning to the threshold before applying the easements, the guidance provides that a local authority should only take a decision to begin exercising the easements when the workforce is significantly depleted or the demand on social care is increased to an extent that it is no longer reasonably practicable for it to comply with its Care Act duties as they stand prior to amendment by the Coronavirus Act, and where to continue to try to do so is likely to result in urgent or acute needs not being met, potentially risking life. Any change must be proportionate to the circumstances in a particular local authority. So the guidance sets there a very high threshold for the application of the statutory easements in terms of what must be met in substance before a local authority relies upon them. But it also imposes important procedural obligations in terms of how any decision to apply the easements needs to be taken. So a decision needs to be agreed by the Director of Adult Social Services in conjunction with the principal social worker. The lead member for social care needs to be involved and briefed. The Health and Wellbeing Board should be kept informed, and decisions should be fully informed by discussion with the local NHS CCG leadership. So in other words, as well as the internal decision-making process being specified as to who within the local authority has to take the decisions, there's also there a requirement for prior discussion with local NHS as well. And the guidance emphasises the importance of record keeping in relation to any decision to apply the easements, setting out in particular that the record should, where possible, include the nature of the changes to the demands that it's facing or the workforce that have given rise to the need for application of the easements, the steps that have been taken to mitigate against the need to apply the easements, the expected impact of the measures that are being taken, how the changes will help to avoid a breach of people's human rights at a population level, the individuals involved in the decision-making process, and the point at which the decision will be reviewed again. So that sets out quite onerous requirements in relation to record keeping of local authority decision-making when it's considering applying the easements. The guidance also imposes a clear obligation in relation to communications, requiring that the decision be communicated to all providers, service users, carers, and local MPs, and that specific consideration needs to be given to the accessibility of the communications to service users and carers. And the decision needs to be reported to the Department of Health and Social Care, which in turn, it seems, will notify the CQC amongst others. More detail still is provided as to the substantive tests and procedures that need to be followed in some of the annexes to the guidance. Effectively, the guidance identifies 4 different stages at which a local authority might be operating. Stage 1 is characterised as being business as usual. Stage 2 is where a local authority doesn't need to apply the easements under the Coronavirus Act, but applies such flexibility as exists under the pre-amendment Care Act. For example, by changing how an assessed need is met in view of the fact that a particular service provider may no longer be accessible because of social distancing. and also recognising that even as things stood under the status quo ante, there might still be circumstances in which there are short-term changes, delays or cancellations to services that can, as it were, occur in the usual run of things, and that may be more frequent in the current circumstances. Stage 3 is operating under the easements themselves, and again, the guidance underscores the importance about being clear as to why the easements need to be applied and their impact. And then stage 4 would be circumstances in which the local authority needs to take decisions about prioritising care and support at a whole system level. And in that situation, as well as the procedural obligations that I've already set out, an emergency decision meeting of the Director of Adult Social Services should be called, and a 2-week review period should be imposed with the principal social worker, the guidance emphasising that the service should be resumed as soon as reasonably practicable. The guidance also provides some further suggestions in relation to the streamlined process for decision making, emphasising that even if the formal procedures aren't in place, there should still be, to the extent possible, an assessment of need, and that needs to be recorded in order to evidence the local authority's decision making, as well as providing some guidance in relation to some of the alternative forms of assessment that might need to be used. So how have these easements been applying in action? Well, it's really a credit to the enormous amount of effort that has been put in by local authorities to keep the usual show on the road, that to date, only 8 local authorities have needed to rely upon the easements for any period of time. And at least according to the latest information on the CQC's website at the moment, only 1 local authority currently has a notification that it's relying upon the easements in place. And there hasn't to date been any situation in which the court itself has had to consider how the easements apply either substantively or procedurally. But it is worth noting that there has been at least one challenge at a pre-action stage, that being a challenge to a decision by Derbyshire to apply the easements to reduce certain home care services, which it characterised as being non-essential. That challenge was brought in a letter before action on the basis that Derbyshire hadn't provided information about why it was satisfied that the threshold tests were met, or whether and how the consultation and notification requirements had been satisfied, or effectively communicated the decision to service users and their families. And although it isn't entirely clear to me from the open source information that I've accessed exactly what concessions were made in the response to that correspondence, it seems that Derbyshire was able to put in place satisfactory assurances and revisions in relation to its communication so that the matter didn't need to go any further. But as it's a thread running throughout the guidance, it will plainly be very important that if a local authority does face a situation in which it needs to apply the easements, it will need to keep very clear records of its decision making, both to show that the procedural requirements have been followed, but also to show why it's considered that the substantive test has been met. Another question, of course, that arises is, well, if the easements are in play, in what circumstances will it be necessary for provision to be made in order to avoid breach of convention rights? And in relation to the individual service user or their carers, it's most likely that it will be Articles 2, 3 or 8 of the convention that are going to be in play. Now, Articles 2 and 3, of course, are absolute obligations, which aren't subject to any balancing, but when considering them in their guise of positive obligations on the state to take action, regard is had to the practicalities of doing so and the realities of the resources that are available to states in order to fulfill their functions. Article 8 is, of course, a qualified right and does explicitly allow for balancing, but it can be difficult in relation to all 3 to consider exactly how they will apply in practice. And so I've set out in this slide some examples of cases to which it might be useful to refer should there be any uncertainty in a particular case as to whether or not provision is needed in order to avoid a breach of rights. So first of all, the case of McDonald and UK, which you may recall was the case involving a retired ballet dancer who had been assessed as having a need for support to use a commode at night, which the authority hadn't then been providing, which need was then reviewed so that it was concluded that in fact provision of sanitary pads would be an acceptable alternative. And in the UK courts, a challenge failed in the Supreme Court, and in the Strasbourg court, that court accepted that there had been a breach of Article 8 in circumstances where there was an assessed need which wasn't being met, but concluded that from the point at which the need had been reviewed and reconsidered, the authority's conclusion that sanitary pads would be an appropriate alternative was a proportionate decision, having regard to the specific circumstances in terms of the impact on the individual's dignity, and also on the importance of ensuring that the local authority could husband its resources effectively to meet the needs of all of its service users. I suppose what that gives rise to a potentially interesting question in terms of how the test of looking at whether or not there would be a breach of rights is supposed to be applied, because in that case, the reason why failure to meet an assessed need was found to be unlawful was that the interference wasn't in accordance with the law, because under the domestic statutory framework, the authority had a duty to meet assessed needs. It's obviously more difficult to see how that applies in circumstances where the local authority's duty is simply to make provision to the extent that's needed to avoid a breach of convention rights, because it would be circular then to rely simply upon the assessment in domestic law. So I suspect that what's intended by the guidance is that we're looking more at the circumstances in which there would be either a positive obligation to make the provision, or in which withdrawing an existing provision would have such an impact on the individual that it would amount to a breach of their Article 8 rights. And it's important in that regard, I think, to note that the fact that a service is something that is already in place for somebody is a factor which may make it more likely that there is a duty to continue to provide it than if it's something that had never been provided to them at all. In domestic law, there are a number of cases which can be referred to. We don't have time to look at them at the moment, but I've set out the references there. And finally, and very briefly, just by way of exemplifying business as usual, the case of Raja and Redbridge is an interesting case in relation to the authority's obligations to provide for needs pending a full reassessment. An interesting example of a case where the court did conclude that there was only one way in which need could be met, and it wasn't the way the authority had chosen to do it. That's all I've got time for at the moment, but if there's any questions, I'd be delighted to see if I can answer them.
Yeah, Jack, that was really interesting, especially thinking about all the possibilities. And one of the things that I think is worth thinking about, and I wondered what you had to say about it, was that we are still worrying about a second wave. And although, as you say, local authorities have coped incredibly well, and those that have had to use the easement, many of them are coming out of it, I wonder whether there's a sort of risk of attrition, and if there is a second wave, whether more people might have to use it. What do you think about that?
I think that's the risk of a second wave is obviously a very real risk, and that's something that local authorities are going to have to be carefully considering in terms of their planning now. First of all, in order to try to avoid needing to use the easements then, but I think also making sure that they have processes in place so that if they do consider that they might need to do it, they've got everything teed up in terms of who's going to be making the decisions, how they're going to ensure that there's appropriate record keeping, and what sort of consultation they're going to embark upon with the other with those indicated in the guidance.
Yeah, I think that's really good, because I think it's a kind of issue that in one sense you can feel like it's gone away, but I don't think it has.
Yeah.
So I'm going to hand over to Tom Amraoui now to talk a bit about education.
Thank you, Fenella. I'll just bring the slides up on my screen. So hopefully everyone can see that now. And we've got a slideshow. So I'm going to give an update on education law, but it's really going to focus on special educational needs, because that, I think, is the area where the impact of coronavirus on the law and the duties has been very acute. And of course, it directly affects the most vulnerable children and young people. And the presentation is going to be in two parts. The first part is about the modification, the easement of the Section 42 duty. And I should say on this that I'm indebted to our colleague, Steve Broach for having produced the slides which I have nabbed to prepare this part of the presentation. The second part then goes on to look at modification to the timetables, the timescales that apply to various stages of the EHC process. So starting off then with Section 42, and to adopt Sian's language about normal times, this is the duty that would apply in normal times before an easement has been brought in as it has. So this is the absolute bedrock duty under the Children and Families Act 2014. Local authority must secure the special educational provision for the child or young person, and that, as you will know, is set out in Section F of an Education, Health and Care Plan. And it's been made clear by the courts that this is an absolute duty. So given you the N and North Tyneside case, it is not a duty in normal times simply to use best endeavours or reasonable endeavours. It is an absolute duty to arrange for, to deliver the provision that is set out so that children with an EHCP get the provision that is contained within it. This has been modified quite dramatically by the Secretary of State using powers contained in the Coronavirus Act 2020. The way in which this has been done is by issuing two notices. So the first notice, which has now elapsed, was in force during the month of May. And there is a new notice, which is currently in force, that extends through to the end of this month. Query whether there will be a further one beyond that. We don't know yet. People can speculate about it. I think for what it's worth, it is likely that this is going to be renewed and there will be a further notice. But for now, they seem to be on a month-by-month rolling basis. So what does the notice do? Well, essentially, it modifies that bedrock Section 42 duty by downgrading it to a duty to use reasonable endeavours. That's the key phrase, reasonable endeavours, to discharge the duty during the period which the notice is in force. The government have justified issuing the initial notice and now the subsequent notice in the following way. They point to reduced staff resources within local authorities as a consequence of COVID-19, the fact that many young people and children with plans are being educated at home, that the normal educational programs have been significantly disrupted. And in addition, there are problems with CCGs about deploying staff or having to reprioritize services. So for all of those reasons, the government says that this downgrading of the duty, this easement, is necessary and proportionate. Bear in mind that there is, as I understand it, a legal challenge in the pipeline, both to the notice and to the amendment regulations. I'm going to come on to address the amendment regulations later, but be aware that this is in the process of getting into the courts. So I would expect at some point we will have some judicial guidance on how this is expected to operate and perhaps to the lawfulness of the easement regime in totality. For now, the notice justifies what the government has done in a variety of ways. It points out, for example, that there are unlikely to be sufficient specialist staff to deliver provision remotely. I would have thought that applies in particular to specialist teachers, teaching assistants and so on. That it may not be possible to deliver some provision remotely, and that even if some equivalent could be delivered, it wouldn't constitute securing the provision in the usual way as required by the 2014 Act. The government's guidance makes it clear, and indeed the notice itself makes it clear, that the modification is expected to be different on an area by area basis. So the expectation is that local authorities will respond to the changing situation in their specific area based on various demands related to COVID locally, including, of course, workforce capacity within local authorities, capacity within schools and capacity among specialist professionals such as speech and language therapists, occupational therapists who work in this area. And it also makes it clear that local authorities can and indeed should look to arrange reasonable alternatives to the usual provision of special educational provision during the outbreak when the notice is in force. Guidance has been published alongside the notice, and this makes clear, which is really quite straightforward, but it's worth saying it anyway, that the basic point is the provision is temporarily likely going to have to be different to that which is set out in the EHC plan. So usually you will have in section F of an EHCP a quantified, specified, detailed provision that must be delivered. And if it's not delivered, parents are able to challenge that non-delivery by way of judicial review. Now, of course, with the notice, there is an expectation that temporarily the securing of that provision is going to be different. It's a reasonable endeavours duty. So what does this reasonable endeavours duty actually look like in practice? Well, first of all, there are likely to be differences to the provision that is set out in the plan. There will be differences to the location in which that is going to be delivered, differences to the frequency, so how often provision is going to be delivered. For example, again, therapies is the classic one. And the method of delivery is also apt to be changed, for example, by using video technology. And also changes to staff. So very often a plan will specify a particular specialist or a person holding X and Y qualifications must be the person who delivers the provision. Under the easement regime, there is an expectation that that can and is likely to change. What are the implications of this? Well, I think first of all, it's not too much of a stretch to say that simply doing nothing is very likely to be treated as unlawful. There can't be a blanket approach of saying we will simply cease any and all endeavours to implement a plan. What does need to happen is that local authorities should again use their reasonable endeavours to set out what is provided in sections F and also social care in section G, whether that's in the form specified in the plan or more likely in some modified form. And the guidance talks at length about this concept of co-production, co-partnership. And the idea here is that local authorities should, as far as they can, reach out and work with parents or young people themselves, as the case may be, to try and find new and creative ways of delivering special educational provision. Again, the classic example is likely to be virtual working, just as we're doing now with this webinar. In terms of whether it is likely to be easy for challenges to be brought against individual decisions of local authorities in respect of easements, I would have thought that it's not going to be easy to bring those challenges, because if the whole concept is about using reasonable endeavours, you might think that built within that very language is a Wednesbury defence. So if a local authority can show that it did all that was reasonable, taking into account a range of factors in an individual case, that approach is, I think, very likely to be able to withstand scrutiny. Bear in mind that in section 66 of the Children and Families Act 2014, there is a best endeavours provision which falls on the shoulders of, among others, schools themselves. And I think it is likely, if this hasn't already happened, I'm sure it has, that a lot of the legwork is going to have to be put in by schools. And notice the difference in language here. So it's a best endeavours duty that falls on schools, whereas it's a reasonable endeavours duty that is currently on the shoulders of local authorities. And I think with my lawyer's hat on, best endeavours is a higher test. It is a more stringent test than reasonable endeavours. So again, a lot of the responsibility is going to fall onto schools. And bear in mind, lastly, that there is no change to social care duties to children with social care needs in addition to their special educational needs. So the whole regime of section 20, section 17 of the Children Act still applies fully at this time. In terms of the modification of timescales, there are two documents that you'll need to look at. The first are the 2020 amendment regulations themselves, And then there's quite extensive guidance that's been published by the government alongside that. That's guidance published on the 30th of April 2020 and is still in force. There's quite a lot of detail here in the slides that will follow, but I'll just give you a whistle-stop tour of the main points. First point to take away is that it's only some aspects of the law on EHC needs assessments and plans that have changed temporarily. The modification is to the timescales, the time frame. It's not to the underlying duty itself, with the exception of the Section 42 duty, which I've already covered. And so what we see here really is a very significant relaxation of the deadlines for various aspects of the EHCP process, and that is going to be in force for as long as the regulations themselves are in force. They came into effect on the 1st of May, and they are currently in force until the 25th of September. There is, of course, a possibility that they may be renewed after that point. We don't currently know, but we do know that there is a duty for the Secretary of State to review the effectiveness of the regulations during the period for which they have effect, and that is set out in the regulations themselves in Regulation 2.1. This relaxation of the timescales applies whenever the so-called coronavirus exception can be invoked by the local authority. And this is where the timetable is going to be relaxed for a reason relating to the incidence and transmission of coronavirus. That's the key test. So it's not possible to miss a deadline for any other reason. That would be almost certainly unlawful. But if there is, because of, for example, a workload difficulty in a local authority or a problem consulting with the school because of the incidence and transmission of COVID, then that means that the exception can apply. Where the exception does apply, the deadline is essentially softened to one which is as soon as reasonably practicable. Which timetables and timescales are affected? Well, the changes are very extensive, and for the full list, I would direct you to Annex A of the guidance. This isn't a full list, but you will see from this that it's very extensive. So, for example, the determination of requests for EHC needs assessments, decisions on whether to issue a plan, and then the preparation and issuing of plans themselves. All of that is potentially affected by the regulations. Annual reviews are also affected. The process relating to mediation is affected. And the actions that a local authority must take, or a health commissioning body, or a social care department, whenever the tribunal makes non-binding recommendations under the national trial, that is also relaxed under the new regime. So to give you one concrete example, practitioners in this area will be familiar with the usual 20-week deadline that applies from the moment the local authority has made a needs assessment all the way through to the issuing of the EHCP. Usually 20 weeks applies to that. That is now able to be relaxed if the coronavirus exception applies. That is downgraded to a duty to do so as soon as reasonably practicable. So the question, of course, is how radical is this? I think it is a very extensive relaxation of the deadlines. It is, as I say, temporary. Regulations were in force until September, but clearly there is the potential for the usual timetable to slip in a very significant number of cases. It's important to realise that the substantive requirements of the process for assessing needs and issuing plans hasn't changed. So if, for example, parents make a request or a school makes a request for an EHC needs assessment, if the statutory threshold for that assessment has been satisfied, then the basic duty to carry out the assessment still applies. What has changed, of course, is the timetable within which that process needs to take place. Significantly, there is an exception here to the 15 days that the parents or the young person themselves, whichever the case may be, must be given in order to make their views known to make representations on a draft plan. That isn't affected at all by the amendment regulations. And it's also worth noting that under the regulations before amendment, there were already certain legitimate grounds on which a local authority could extend time for the various stages of the EHC process. So although this is a very big change, it is not a complete across-the-board change altogether. In terms of lawfulness and good practice, I think the following points are really important. So it is likely that any blanket approach on the part of a local authority is likely to be challenged in the court. So if, for example, local authority were to say, we are, as a matter of policy, in all cases, going to take X number of weeks or months longer to complete this aspect of the EHC process, that is, I think, likely to be amenable to challenge. The guidance, and I think just plain common sense, suggests that local authorities should try to find creative ways of working to try and ease this burden of reaching timely decisions. Because one thing that I think all practitioners and certainly local authorities would want to avoid is for there to be a big backlog of cases building up, and then when the regulations no longer take effect, for all of a sudden a big logjam to have built up. So it would be far better, if at all possible, to stick to the current timetables, and if they are going to be eased, not to ease them by too long. Last but not least, just to make a note about practice in the Special Educational Needs and Disability Tribunal. As many of you will know, this has now moved to fully virtual working. So there are no in-person hearings, it is all telephone hearings or video hearings. That's been in force for a number of months, and all the indications are that that is going to continue for the foreseeable future, possibly into August, September, maybe even later than that. There are a number of practical implications that arise from this. I've put them in the final slide for those who are interested. My own impression, having done a number of these hearings over recent weeks and months, is that it is a little bit clunky. There are sometimes technical problems, but by and large, it is working. So let's see if that continues in the future. As I say, that's been a whistle-stop tour of education, special educational needs, and I'm happy to see if there are any questions arising from it.
Yeah, thank you very much. That was really so helpful. One of the questions that came up right early on was, do local authorities need to apply for these SEN easements in the same way that they need to under the Care Act?
No, I don't think that they do. So my understanding is that the notice has modified the Section 42 duty for all local authorities. So it's not a case of needing to make any application. That the law has been modified during the period which the notice is in force, and the same applies to the amendment to the timescales that can be invoked by local authorities during the period for which the regulations are in force.
So I wonder whether I can hand over to Sian for one of these questions that's been lurking on the Q&A.
Yeah, this is actually one which I think possibly spans both Fenella's and Jack's presentations. So this is a question about the Care Act easements, and in particular arising out of that Derbyshire threatened judicial review that Jack was talking about. Where, as I understand the position, one of the grounds of proposed challenge was lack of consultation before the easements were imposed. Given that these easements are meant to relate to an urgent situation where there is a severely depleted workforce and an imbalance between need and ability to meet need, is there a requirement to consult before the easements are applied for?
Well, there are certainly people that you have to communicate with, and I suppose any local authority would, generally speaking, expect to have a sense that this kind of crisis was coming. And so there does have to be, I think it's quite interesting when I first started looking at these provisions when they came in, there's a huge amount of work that has to be done in terms of communication before somebody can actually use them. And I mean, it's interesting to me that as many local authorities did go through that process. Jack, have you got anything to add to that?
So the guidance itself doesn't impose or refer to there being, as it were, a general obligation to consult with the local authorities area as a totality. What it specifically refers to in terms of the decision-making process are the individuals within the authority who have to agree, the fact that there are duties to keep informed rather than, as it were, consult with the Health and Wellbeing Board, and that that decisions should be fully informed by discussion with local NHS, CCG leadership. So in terms of what the guidance itself says, it doesn't refer to a more general duty to consult. Of course, whether there would be such a duty will depend upon at common law, as it were, will depend upon the circumstances, which will include the urgency and whether or not this is something that, as it were, couldn't be predicted or anticipated, or whether it's something where there would have been some scope to elicit wider views.
One of the other questions that we've got here, and I wonder whether any of you would like to comment on it, is that there's a concern that there's going to be a sort of huge backlog of cases, and that's going to lead to judicial review pressure, you know, in the autumn. Have any of you got a sense of that? Tom?
I think that is likely. The crunch point, I think, is likely to come when the Section 42 notice is no longer in force, and we hopefully look forward to a day when it isn't. At that point, in theory, all of the provision that needs to be made for children and young people with special educational needs becomes once again an absolute enforceable duty. And I think it is it's not too much speculation to say that with the disruption to schooling that is going on at the moment and is likely to continue, that is going to lead to a very big backlog. The interesting question, I think, will be if challenges are brought in those circumstances, whether the courts would take perhaps a more pragmatic and lenient view than they might otherwise do, because, as I said right at the very start, the basic duty is so very strict, and it is difficult to reconcile that with a situation when the notice is not in effect. So I think that is a very real concern, as it is going to be coming down the pipeline.
I suppose there's an interesting point, isn't there, that as well as judicial reviews stacking up, actually needs are stacking up, that, you know, educational needs, care needs, health needs are all not being met at the moment. And so at some point, all of those needs are going to become so urgent that they're going to have to be addressed because they've become worse over time.
So there's another question about the Care Act easements, and I don't know whether, Jack, you might be able to help us with this. We're being asked what the timescale is for review of those easements and when there might be an update, presumably as to when they're withdrawn or whether they're going to be allowed to carry on. Have you got any insight into that at all?
So again, the guidance provides specifically that if easements are at what's characterised as stage 4, then they have to be reviewed by the principal social worker on a 2-weekly basis. It isn't otherwise prescriptive in terms of the timescale for review, but they're only to be in place for so long as they're required, and the local authority has to return, as it were, to normal service as soon as is reasonably practicable. That's obviously going to depend upon the particular circumstances of the case, but the emphasis is very much on these being short-term rather than long-term measures. And that seems to be how they've been applied in practice, because of the, I think, 8 local authorities in total that have had easements in place at some point, 7 have entirely ceased to rely upon them. And even within those authorities, they were applied, as it were, at different stages at different times.
So I'm going to just go to one last question for Tom, which I think is really, really interesting. And it's, given the disruption to education over the last year, do you think there are any grounds for people who have got a plan arguing that they ought to be provided with an additional year of provision?
I think that is going to be an argument that will be used persuasively in lots of cases, because the test for ceasing a plan is that it's no longer necessary. And so you can see the argument being made that ordinarily a young person would have made a certain level of progress over time. If that has slipped and been disrupted because of coronavirus, then the argument becomes, well, it is still necessary to have a plan, therefore the local authority can't lawfully cease it, and if they did, it would be challenged in the tribunal. So I think the answer is a qualified yes.
No, that's really interesting. Well, thank you very much, all of you, for speaking. Thank you very much, all of you, a huge number of you, for joining us and sending us some fantastic questions. And hopefully we'll either see you face to face before too long, or there'll be another webinar coming up with some more updates. Thanks very much. Goodbye.
Thank you all.
Bye. Thank you.
Bye.
Bye.